Micheal Jackson passed away in 2009, but the settling of his estate continues more than 15 years after his death due to a lingering tax dispute with the Internal Revenue Service (IRS) and other legal challenges, including a lawsuit brought by his mother over a deal to sell part of his music rights to Sony Music Group for $600 million. A Los Angeles appeals court issued a ruling in August 2024, allowing the deal to proceed over the objections of Katherine Jackson, who argued that the transaction with Sony violates the terms of Micheal's will and runs counter to his wishes. The sale will now move forward, providing money for his heirs and valuable estate planning lessons about trusts and controlling assets from the grave. Background on music sale legal dispute. According to the terms of Micheal Jackson's will, his entire estate is to be turned over to the Micheal Jackson Family Trust. The primary beneficiaries of the trust are his 3 children and unnamed charities. John Branca, an attorney, and John McClain, an accountant, are the trustees of the trust and the executors of Jackson's estate. Trustees and executors have similar roles: the winding down of a decedent's affairs, but in different contexts. A trustee manages accounts and property owned by a trust. An executor, called a personal representative in some states, is responsible for managing a deceased person's probate estate, which consists of accounts and property in the deceased person's sole name that did not have a beneficiary at the time of their death. Through the probate administration process, Katherine, Jackson's mother, is a life beneficiary of a portion of a subtrust, the terms of which give the trustees sole discretion to manage the trust assets, accounts, and property owned by the trust for Katherine's care, support, maintenance, and well-being. When Katherine dies, any remaining assets in her subtrust pass to the children's share of the trust. Jackson's will was admitted to probate in 2009, but his estate remains frozen due to a long-running tax issue involving $700 million allegedly owed to the IRS. A May 2024 court filing shows that, as long as the legal dispute continues, the family trust cannot be funded. In the meantime, however, the family is receiving payments through an allowance provided by the estate and its executors. In 2010, the probate court authorized the executors to continue running Jackson's businesses because the estate is still pending before the court. The executors had to seek court approval to move ahead with a deal between the Jackson estate and Sony Music to purchase half of the King of Pop's publishing and recorded masters catalog, called the MyJack catalog. When they brought the deal to the judge, Katherine filed objections. Jackson's children initially sided with their grandmother in opposing the transaction, but after the probate judge ruled last year that the deal could proceed, they accepted the decision. Katherine subsequently filed an appeal. The appeal spawned a separate lawsuit between Katherine and Jackson's son, Biggie, who argues that it is unfair that the estate should have to fund her lawsuit against the executors when the Jackson children already decided an appeal was not in their best interests. In a court filing, Biggie's lawyers wrote that participating in an appeal was a waste of resources because the chances of a reversal would be an extreme long shot. It turns out the lawyers were right. The appeals court sided with the probate court and ruled that the estate can proceed with the sale to Sony, denying Katherine's attempt to block the agreement. Sony will now have a stake in what Billboard says could be the largest valuation of music assets ever, an estimated $1.2 to $1.5 billion.